Well, thank you very much for this kind introduction, and many thanks as well to ERA for inviting me to speak at this rather wonderful conference. I would like to use the half hour allocated to me to discuss some issues in respect of state aid for sports. I would like to look at a number of Dutch football cases, and then followed by a number of Spanish football cases. And then lastly, I would like to shed some light on state aid for sports infrastructure under the general block exemption regulation. To start with the Dutch cases, as the ministry I work for was involved in these cases, so I'd like to spend some time discussing these. On the slides, a map of the Netherlands with the logos of the football teams involved. In the Netherlands, everyone likes to discuss football, and that doesn't change even though the national team is in a quite dire situation at the moment. I can imagine the logos behind me on the slides are not that well known for everyone. That also shows that the teams under investigation are rather small, perhaps with the exemption of PSV Eindhoven, multiple winner of the Dutch league. The other teams play in the Dutch highest league, but also a number of them play in the Dutch second division. And we will see when we look at the Spanish clubs a bit later that those investigations did focus on, for example, Real Madrid and Barcelona, which actually led the the president of the Spanish Football Association, as I read somewhere, to state that the European Commission investigates Spanish football because of the many titles that are won by Spanish football teams. As a Dutch football fan, I can assure you that is not true, because if that is a decisive element, the Dutch football teams would have never been on the Commission's radar in the first place. So let's start with the Dutch football cases. In the Dutch football cases, the Commission's investigation actually revolved around one central question, and that is whether the Dutch authorities, so the Dutch local municipalities involved, behaved in line with the market economy operator principle, and thus whether they have granted an advantage to the football clubs involved, or whether, if they actually acted in line with the MEO test, have avoided state aid altogether. In this respect, the Commission has compared the behaviour of the Dutch municipalities to a hypothetical private investor or a hypothetical private creditor, and looked at whether the transactions undertaken by the Dutch municipalities would have also been acceptable for a private investor or a private creditor. And in this regard, it is important to note that a private market operator would always be after profit maximization. For a private operator, a simple transaction that is neutral to your budget is not sufficient. A municipality might say, well, we have undertaken this measure in respect of football club A, and we have not made a loss by doing so. That is insufficient, because for a private operator, he would never enter in such a transaction, because there is no profit to be made. He will also look at the risks involved, at the possible benefits to be achieved, and would then make a decision as to whether to enter into a transaction or not. So simply avoiding a loss, making sure a transaction is neutral for your budget, is insufficient to fulfill the market economy operator test. The other state aid criteria, as laid down in 107 paragraph 1, were all met. State resources were present. The measures could all were all imputable to the state. Football clubs, professional football clubs, are undertakings. The measures had a selective character, and trade could be distorted, and an effect on competition could not be excluded. In respect of that last condition, I do find that a bit debatable, especially in regard of the smaller football clubs. So if we, for example, go back, you see the light white and blue football club logo of FC Den Bosch. Den Bosch is a small town in the southeast of the Netherlands, and the local football team has actually never participated in any European football tournament. However, the Commission quickly then stated that that is not decisive, as football teams do also operate on other markets, for example, player transfers. Yes, I do agree with that. Merchandising and sponsorships. I myself lived in the local area of Den Bosch, within half an hour of Den Bosch, and I can assure you that I have never seen anyone with a Den Bosch scarf outside the city of Den Bosch. So I don't think the market for merchandising of Den Bosch memorabilia is EU-wide. And in these times, football clubs are very happy if they have a sponsorship deal in the first place. And if you look at the type of sponsors they manage to attract, especially the small Dutch football teams, these sponsors are all local enterprises, local undertakings. We're not talking about big multinationals. We're not talking about massive multi-million pound or multi-million euro deals. If they get a sponsorship deal of several hundred of thousands, that is a very good deal, especially for the smaller football teams. So the question as to whether the measures in respect of the smaller teams could affect trade, in my opinion, remain rather, well, slightly debatable. But I do agree that the player transfer market is certainly EU-wide, certainly has an EU dimension. However, the central question, as I just said, did the municipalities grant an advantage to the football clubs involved by not acting in line with the market economy operator principle? On the slides, I've included all 6 of the teams involved. However, due to time constraints, I will only discuss 3 of them. The details of the others you can, like I said, find on the slides, and also I'm happy to discuss these a bit later or during the Q&A session. The first team that I'd like to have a look at a bit further into detail is Vitesse. Vitesse plays its games in the highest Dutch league. I would say just below the top teams of the Netherlands, from the municipality of Arnhem. And in the late 2000s, Vitesse encountered some severe financial difficulties, and at its own request was admitted to the so-called suspension of payments procedure under Dutch insolvency law to allow the club to enter into negotiations with the creditors to come up with a draft agreement to restructure the debts of the football club. And Vitesse had 61 creditors, and the draft agreement that was drawn up between all the creditors was accepted by 60 out of 61 creditors. It was only the municipality that in first instance did not accept the draft agreement, because the municipality thought that it had secured its claims via a separate agreement in which also a penalty clause was involved. However, under Dutch insolvency law, such an opposing creditor can be set aside if half of all the other creditors, who also represent in addition more than half of all accepted claims, are in favour of the agreement. And in this event, well, 60 creditors were actually in favour, and although the municipality of Arnhem was the major creditor, it did not represent more than half of all accepted claims, which made the bargaining position for the municipality rather weak. So eventually, the municipality did accept the creditors' agreement and managed to receive approximately 12% of its claims. And important is that all the other creditors also received 12% of the claims. So the municipality managed to get a deal that corresponds with the deal that all the other creditors got. Moreover, if the deal was rejected, Vitesse would in all likelihood have gone bankrupt. And in that event, all creditors would have probably received much less of their claims, and actually the agreement reached, the payments that were agreed exceeded the sum of assets on the football club's balance sheet. And if the club would go bankrupt, all the players could freely transfer, which would mean that the assets on the balance sheet would further reduce. So the Commission, in its opening decision, came to the conclusion that yes, Vitesse, the municipality, did act and did behave in line with the market economy operator principle in this event as a creditor, because a private creditor, as is the case in this decision, would also accept the agreement, and did also accept the agreement. So the Commission agreed that the municipality got the best deal possible, a deal that is also acceptable for a private creditor. And therefore, even though only 12% of the claims were paid out, the municipality did act in line with the private creditor test and did not confer an advantage to the football club. So in this case, no state aid was present. In the next case, which evolves around PSV Eindhoven, the Commission reached a similar conclusion. With respect to Eindhoven, again a club that came into severe financial difficulties, the municipality agreed on a sale and lease back construction. The municipality would buy the land under the stadium and would then lease it back to the football club. So from a perspective of a normal market operator, you would ask the question, well, the purchase of the land, was that done under normal market conditions, or did the municipality pay too much? And then in respect of the lease fee, is the lease fee also granted under normal market conditions, or does the municipality lease the land under the stadium for a price which does not reflect market conditions? Well, in this case, the municipality of Eindhoven had carried out an independent ex-ante valuation of the land under the stadium, and in this valuation, the municipality looked at foreseeable, realistic development opportunities of the land. Important here is that the stadium is located right in the city centre of Eindhoven. So in the event the stadium would disappear, this land would probably be used for apartment blocks, shopping centre, or such use of land, not for another sports stadium. So the assumption taken was this land could be used for apartments, shops, etc. And these assumptions were also reflected in the lease fee, which meant that the lease fee paid by the football club is actually higher than if the lease fee would be calculated on the basis of the use of land as a sports stadium. In addition, the assumptions taken by the valuation firm seemed to be conservative compared to other local development projects. In addition, various other safeguards were included by the municipality. The municipality arranged that PSV provided a guarantee for the sale of for the rent payments. The guarantee was provided based on the income of season tickets. In addition, there was a safety deposit fund in which the football club was obliged to put 5 million euros. The lease fee could be reviewed after 20 years on request of either of the two parties, so the football club or the municipality. And another important aspect is that if PSV were to default, the use of the stadium would fall to the municipality. And this is a deviation of Dutch civil law in which the use of a stadium, a leasehold, would fall in the bankruptcy estate. So if PSV would go bankrupt, the municipality managed to get a very good position in that it would remain landowner, but also control the use of the land. So a deviation of Dutch civil law in the benefit of the municipality. What the Commission also did is to take a loan transaction as a benchmark. Would a private creditor, would a private investor receive a better return rate if a loan would be granted instead of engaging in this so-called sale and lease back construction? The Commission concluded that a loan would have about 1% higher return rate, but then immediately stated that a private investor would be probably willing to forgive this slightly better return based on the deal that the municipality managed to get. If PSV would go bankrupt, the municipality has the land, which in all likelihood will increase in value. It controls the use of the stadium, and if you would grant a loan, in the best case scenario, you would get back the nominal value of the loan, but you would not own the land or control the use of the stadium. So a private investor would probably be willing to forgive this. All in all, the Commission also in this case concluded that the municipality of Eindhoven did not grant state aid, acted in line with the market economy investor principle. These are the two clubs that relatively got a good deal by the Commission. The other four Dutch football teams unfortunately did receive state aid. I will discuss one. The other three decisions are structured in a similar way, in that the Commission investigated the transactions undertaken by the municipalities, concluded they do not meet the market economy operator test, be it as an investor or a creditor, and therefore state aid was present. In the event of Willem II, a team playing its games in the city of Tilburg in the south of the Netherlands, Willem II got into financial difficulties as well, and the municipality decided to reduce the rent of the stadium and to reduce this with retroactive effect for 6 years. For each year, the municipality reduced the stadium rent with 400,000 euros. So over 6 years, that resulted in a sum of 2.4 million that was granted to the football club. Well, the Dutch authorities firstly put forward that this transaction is in line with the market economy investor principle, but the European Commission took none of this and said that, well, if you reduce the rent of the stadium, this would actually mean that the operation of the stadium would become loss-making, and without any perspective on a return on the investment, such a deal would not be acceptable for a private investor. In addition, a private creditor would also have not engaged in this transaction because there were no corresponding measures by other creditors that were of a similar nature. So this measure was not taken pari passu, and there were no requirements for the other creditors to eventually reach a deal with similar conditions. They were obliged to enter into negotiations, but without any result known of these negotiations, it was uncertain whether the transaction would be carried out in line with the market economy operated principle in the form of a creditor test. And in addition, if the football club would eventually go bankrupt, a new club could be founded which could start playing its games in the stadium. So that neither was an argument that the Commission accepted in this case. So the transaction undertaken and the measure undertaken by the municipality of Tilburg involves state aid. And the Commission came to a similar conclusion in respect of Mva of Maastricht. Maastricht might be better known to you than for the Maastricht Treaty than for Mva Football Club. FC Den Bosch already briefly discussed, and NEC of Nijmegen, not to be mistaken for the Japanese technology firm. However, those four clubs did receive state aid, unlike Vitesse and PSV. These clubs could be seen as firms in difficulties under the 2004 guidelines for rescue and restructuring aid, which have already briefly been discussed by previous speakers. And under these guidelines, firms in difficulties can receive state aid under very rather strict conditions if a number of conditions are met. And if the conditions are met, such aid is compatible with the internal market. However, the conditions that are required by the Commission in the guidelines are quite stringent. Firstly, there has to be a plan that leads to the restoration of the long-term viability of the club. The plan has to include a best case, a worst case scenario, all sorts of other conditions need to be taken into the plan, and also the restructuring aid has to avoid any undue distortions of competition. And for example, in the event of Willem II, a number of compensatory measures were taken. A cap on wages was introduced, the number of players was reduced, the number of employees of the football club were introduced to avoid distortions of competition and to avoid giving this football club an unfair advantage over other firms, other football clubs that were not in difficulty and did not benefit from this aid. The aid has to be limited to a minimum, in the event, for example, again, of Willem II, a medium-sized enterprise, only 40% may come from public resources and the other 60% has to come from the club itself or external financing. This, again, was met by the Dutch football teams. Such aid is Member States have to provide annual reports for such aid to the European Commission so they can keep an eye on what is actually being granted. And the one-time, last-time principle applies in that during a period of 10 years, a firm may only once receive rescue and or restructuring aid. As in the case of the Dutch football teams, these measures were all in line with the 2004 guidelines. The aid was actually compatible with the internal market. So there was state aid, but such state aid was compatible. If we look at the Spanish cases, we could see that these are, well, completely different kettle of fish, really, in that the Spanish clubs all did receive state aid. We have 3 decisions focusing on a number of Spanish teams. Firstly, a decision in respect of Real Madrid, Barcelona, Athletic Bilbao and Osasuna. In this case, there was a preferential tax treatment of these clubs. Under Spanish law, at some point, all football clubs were obliged to change their legal status to sports limited companies, because previously a lot of them were badly managed and their administrators bore no financial liability for this. However, if you could, as a club, prove that in the previous years your management was actually in order, there was no requirement to change your legal status. And the difference in legal status also had an impact on the amount of corporate tax that has to be paid. If you're a sports limited company, as all the other teams in Spain were, you pay 30% tax. Those 4 clubs that were not obliged to switch to a different legal status only paid 25% corporate tax. So this led to an advantage for these clubs, and as all the other conditions for state aid were also met, these clubs actually received state aid. Then the second decision revolves around, again, Real Madrid, and concerns a legal dispute, I think, if I read correctly, dates back to 1991, in which the City of Madrid and Real Madrid entered into a land swap agreement. However, one plot of land to be transferred by the City of Madrid to Real Madrid turned out to be impossible to transfer, because this plot under Spanish law had to remain in public hands. So an agreement was drafted between the City of Madrid and Real Madrid to settle this dispute, and under this agreement, the City of Madrid assumed to, said that they will pay the 2011 value of this plot of land to compensate the football club for the impossibility to transfer this piece of land. However, the European Commission looked at this question from a perspective of a market operator and said, well, would a market operator also have granted this compensatory measure? And firstly said, well, unlikely, because why, as a City of Madrid, do you assume full liability for the impossibility to transfer this piece of land? Because at some point in time, it was known both to the City of Madrid and to Real Madrid that it was impossible to transfer this piece of land. So why, as the City of Madrid, do you fully assume liability for this? Why did you not seek legal advice, which is something a private operator would at least have done before assuming full liability? Secondly, the amount of settlement that was granted was way too high, because the City of Madrid used the incorrect valuation assumptions, and the European Commission found that this plot of land would actually be worth about 5 million as opposed to 22 million that the City of Madrid found. So again, a rather large sum of state aid was granted by the City of Madrid to Real Madrid. The last of the Spanish cases, I'll be brief on that one, relates to a number of football clubs from the Valencia area. They all received state guarantee on bank loans, and because there was no corresponding premium that was paid by the football clubs for this for the guarantee, these guarantees entailed state aid for the clubs from Valencia. So, like the Dutch cases, the European Commission came to the conclusion that state aid actually was present. However, unlike the Dutch cases, the European Commission came to the conclusion that this state aid was actually incompatible with the internal market, and therefore has to be recovered. In the cases revolving around the preferential tax treatment and the settlement of the dispute between Madrid and the City of Madrid, Spain didn't really invoke any justifications. They did put forward Article 107, paragraph 3, under C of the TFEU, under which certain activities can be promoted or certain economic areas. However, the measures granted by the Spanish authorities all amounted to operating aid, and operating aid generally is not compatible under 107.3c, and although sport can be a policy that may be supported by state aid, Article, I think, 165 of the TFU does require that this has a European dimension, and in the Spanish cases there was no European dimension present. The aid was clearly aimed at promoting and supporting certain Spanish football clubs. In respect of the state guarantees for loans obtained by the Valencian football clubs, amongst others, the 2004 guidelines on rescue and restructuring aid were invoked again. However, these could not be met because the conditions that were met by the Dutch football teams were not met by the Spanish teams. Amongst others, for example, Elche and Hercules did not have any form of restructuring plan. Valencia did have a restructuring plan, but did not include, for example, best case or worst case scenarios. And even if the plan was carried out, this would in all likelihood not lead to the long-term restoration of the football club. There was no own contribution. In the event of Valencia, I think it was only 20%, and in the event of the other two Spanish football teams, Elche and Hercules, I don't think there was any own contribution at all. And moreover, Valencia seems to have received rescue and restructuring aid already within the 10-year period, so that one-time, last-time principle was also not met in this case. So state aid that unfortunately could not be declared compatible with the internal market. Let's now move on to sports infrastructure under the general block exemption regulation, the last bit of my presentation today. As previous speakers have already mentioned, the block exemption regulation was significantly expanded and revised in 2014, and a new category was included, namely state aid for sports infrastructure. And aid measures under the GBA are compatible with the internal market and are not subject to the prior notification requirement of Article 108, paragraph 3. So this is sort of an easy way to grant good aid, as the European Commission calls it. The exemption for sports infrastructure is laid down in Article 55 of the GBA, and such aid can be compatible with the internal market and exempt from prior notification if a number of conditions are met. I've listed them on the slide. I'll go through them with you briefly. For example, firstly, the infrastructure may not exclusively be used by a single professional sports user. So if there's a sports infrastructure, this cannot be only used by a professional football club, for example. And access to the infrastructure must be open to several users, and this must be granted on a transparent and non-discriminatory basis. Pricing conditions must be made available publicly in case of use by sports clubs, and the aid also the aid may take the form of both investment aid and operating aid. So the question that then arises is whether you could use the new GBA to grant aid for professional football clubs, and, for example, whether the measures undertaken by the Dutch authorities or even the Spanish authorities could have been granted under the GBA. Well, this, I think, will be difficult on the first, if I look at it, prima facie, because the GBA is not applicable to undertakings in difficulties. And like the previous speaker said, rescue and restructuring aid is not considered to be good aid, and therefore the guidelines on rescue and restructuring aid were introduced so that the Commission can look at such aid in a lot more detail, and therefore this type of aid is generally not included in the GBA, and the GBA cannot be used to grant aid to so-called firms in difficulties. Additionally, state aid has to be transparent under the GBA, and up until the 2017 review, aid measures were transparent. For example, if the aid took the form of a grant or a loan or a guarantee or for instance, tax advantages. However, transactions with land were not seen as transparent aid. However, in the 2017 revision of the GBER, a new category of transparent aid was included, in that aid is now also can be transparent if aid takes the form of the sale or the lease of tangible assets below market rates. So if you have a stadium, for example, as a municipality, you rent this out below market rates, this may be transparent aid. However, you still need to meet the specific conditions of Article 55 of the GBER if you want to grant state aid to sports infrastructure. However, this does show that the scope of the GBER in respect of transparent aid has been widened a bit and does potentially provide local authorities a bit more room to manoeuvre and to grant state aid for sports infrastructure. And additionally also, certainly, the notification thresholds need to be respected, which were also raised during the 2017 review of the GBER. I think this is the end of my presentation. I would like to, I think we can answer questions in the Q&A session.